Hello again. Welcome to Copyright and IP Video 2. In this video, we'll be talking about copyright and IP in the government context, or to be more specific, in the Canadian federal government context. Here in Canada, we have what is called Crown copyright. Any work that has been prepared or published by the Canadian federal government, the copyright belongs to Her Majesty, with some exceptions, such as subject to any agreement with the author. So if the author is not someone who works for the federal government. This is common in other Commonwealth countries, although we're a little bit old-fashioned, I understand, in this respect. But it is not necessarily the way that every government handles this. For example, we won't be going into details. In the United States, works that are created by federal government employees are automatically put into the public domain. There's no copyright at all. Some key points about Crown copyright. And copyright in any work that is created or published by the federal government automatically belongs to Her Majesty, subject to any agreement with the author. So for example, with federal government employees, it's straightforward. Copyright belongs to Her Majesty. However, if a consultant develops a report and the federal government publishes something that is written by someone who doesn't work for the government, there is an opportunity for these authors who don't, or other creators who don't actually work for the federal government, to negotiate to keep some or all of their copyright. Some people find this kind of frustrating. Amanda Wakarak, a librarian based in Alberta, has been a leader in the area of the call to remove Crown copyright from the Copyright Act. So Amanda Wakarak had submitted a personal submission to the Copyright Act review on this topic. This will be a reading for you after this video, so a bit more detail. Just a few points. Amanda lists some of the previous calls to eliminate Crown copyright, notes that Canada is the only country to retain the language from the 1911 UK Act, so we're a little old-fashioned in this respect. She points out that it is confusing because different departments provide different explanations of what people can and can't do with these copyrighted works, and notes that Crown copyright restricts access and is contrary to the spirit of open government. Okay, so the Canadian government has been a leader in the area of open government, and we have an open government license. It's similar to Creative Commons. It's actually compatible with Crown copyright. Her Majesty, as a copyright holder, can waive the rights that she owns if desired. So the basic license grant for the open government license is that the information provider, the federal government, or Her Majesty if you prefer, grants a worldwide royalty-free, so free of charge, perpetual non-exclusive license to use the information, including for commercial purposes, subject to the terms below. So what can you do? You can copy, modify, publish, translate, adapt, distribute, or otherwise use the information in any medium, mode, or format for any lawful purpose. Okay, so very, very broad-based user rights, almost the exact opposite of Crown copyright. Instead of Her Majesty retaining all the rights, Her Majesty is granting virtually all the rights. There are some exemptions, and it's important to understand these exemptions. The license does not grant the right to use personal information. I think that one's obvious. We won't go into more detail on this. Third-party rights. We will go through a bit more detail on this. Names, crest, logos, a bit more detail coming. And information subject to other intellectual property rights, including patents, trademarks, and official marks. So Here's an example of how third-party rights might work. If a government department publishes a report that includes a photograph that is taken from a newspaper or produced by a freelance photographer with the permission of the copyright holder, so that's either the newspaper or the photographer, as a third party, they're not federal government employees, so their works are not automatically under Crown copyright, and they are probably going to retain their copyright. So the government has the right to publish the works, but not to redistribute under the broad-based rights that are granted through the Open Government License. So the government report may be Open Government License, but specific items that are included in the report might not be under that license. The Treasury Board provides details about the official symbols as exemptions. So for example, the Open Government License does not apply to the flag or other official symbols. So as an example, if you go to the Department of National Defense, there's lots and lots of work there, text, that you can copy and reuse under the Open Government License. However, you cannot use DND insignia. They're symbols of who they are. So why? When you think about it, it's pretty obvious. If people could use things like symbols of the government, it would be very easy for people to impersonate government officials and departments. It is kind of related that you can't use trademarks and other official marks, and obvious when you think about it as well. This is the norm outside of government too, and we will have another example from outside of government in the next video. Okay, so we started off with Crown copyright. We're now moving to Open Government License, but not everything has moved over, so we still have this call to eliminate Crown copyright. Why is it so hard to make this a shift? Okay, here's a bit of speculation on this and a little bit of knowledge from my experience. The evolution of government information happened in a context where broad open sharing of information and documents was not feasible. So people didn't necessarily think about all the questions around privacy and security, and even the quality of the material and whether it might be subject to misinterpretation when developing material. The open online environment may actually increase risks in ways that we do not yet fully understand. One example is that we might release data that we think is anonymous. For example, this has happened with health data. We think it's anonymous, we release it, but people can triangulate or combine one data set with another and identify individuals through data sets that we thought had been anonymous. Government departments might have material that we'd like to make fully open. However, a few years ago, those departments might have been told to follow a cost recovery model. Okay, so if the department is relying on cost recovery, getting fees from people who use the materials, unless there is a shift in how the department receives its funding, they might need to choose between continuing to provide the services and continuing with cost recovery, or changing to open government, and without new funding, perhaps not being able to offer the same level of service. Government departments may also have pre-existing relationships and or contracts with commercial partners. So before open government became a possibility, government departments did have ways of providing services that involved the private sector, and it is not necessarily fair or legal in some cases to simply abandon those relationships. That doesn't mean that has to be forever, but in the transitional period, those kinds of things could slow things down. Okay, next, there are two short readings for you: Wakarak's submission calling for the elimination of Crown copyright and the terms and conditions of the Open Government License. After you do those readings, complete the activities for video 2 and then go on to video 3.